Okay, don't stare at me like I'm talking French, but you speak French, so go ahead.
I would understand it. Your Honor, the people hearing them out today, people versus Jerome Burns, we do not believe there is a conflict between Your Honor, this court, and the Office of the Public Defenders. If such a conflict were to arise, we would move to waive that conflict.
Thank you.
Right here, we're seeing both sides reassure the judge there's no conflict of interest. This is a classic courtroom formality, kind of like everyone raising their hands and saying, nope, we're all good. Let's keep the train moving. But remember, anytime the words public defender conflict pop up, it usually hints at something much deeper beneath the surface.
And Your Honor, we, from the Assistant Public Defender, Chinazi Kiriaki-Ruli, representing Mr. Jerome Burns in this matter, we also do not believe that there is a conflict in this matter, and if such conflict should arise, we waive that as well.
All right, very good. Can we get him out?
He's right there.
Or let's go to the case of People State of Michigan versus Jerome Burns.
Good morning, Your Honor. Marie Tenhouse, Assistant Prosecuting Attorney. I'm back to people.
And good morning again, Your Honor. Assistant Public Defender Chinazi Kiriaki-Ruli, on behalf of Mr. Jerome Burns. Mr. Burns, state your name for the record, please.
Jerome Burns. All right, are we ready to continue?
This is where things get spicy. A hidden folder on the defendant's iPhone protected by biometrics? That's digital forensics gold. And when prosecutors can't even open the files on county computer stats, not just a tech problem, that's a legal headache. No one wants to proceed blind when potential evidence is locked away like a boss-level chess in a video game.
Your Honor, a few things. I've been communicating with defense counsel. We have witnesses here. Victim is on her way. Sergeant Matthews is driving her. Personally, I believe they hit some traffic. But we have our other witnesses present and ready. I did want to make a record. We received a great deal of evidence from defendant's phone. As the board likely remembers, we had a preliminary, an extraction. I shared that with defense counsel because it was of potentially exculpatory nature. I was also though very clear that's a preliminary finding. There was ongoing extractions from the phone and analysis that needed to be done. I was initially sent to background to this is that there was at least one hidden folder in the defendant's iPhone that had biometrics associated with it. So essentially they could get into the phone, but they weren't able to get into the hidden folder. So we were looking at options for that. The extraction we received didn't work on any of the county computers, so I was unable to, yes. Ironically, I was unable to pull that up. I had informed defense counsel of having that, but also that I wasn't able to open it. So the next step was asking them, hey, is there another way we could do this where I could actually view this evidence and share it with counsel? I believe it was yesterday. And I will say Sergeant Matthews went above and beyond in trying to.
Quick question for you watching. Should a trial move forward if both sides know there's major evidence they haven't reviewed? Would you want your case decided before the most important files are opened? Drop your thoughts. This is where courtroom strategy meets real-world consequences.
Do things quickly. He was able to get 2 thumb drives, one for prosecution, one for defense, copied over to our office. I notified defense counsel possession of their copy. But it's a lot of information, Your Honor, and a lot of the information relates not only to the preliminary report that I shared with counsel. In essence, it gives a lot more context than what I have been able to view, give context to that first piece of evidence. It's also evidence that we would want to ask the victim about. So the potentially exculpatory information, I believe, would necessitate the victim testifying again, unfortunately, given that evidence, but also the evidence that we are just recently in possession of would speak to that very closely. And I can go into further details at court.
I just want to make sure I'm understanding. So there's evidence that may be exculpatory, which would require the victim to reappear and testify.
Correct. Now, the evidence that we have received as of yesterday, it gives a greater context to that preliminary piece that we shared with defense.
Got it.
The reason for sharing that first is because of the potentially exculpatory nature. I wanted to make sure they had it and they were ready. but of course, there's a lot more to it. And what we have other witnesses. I'm ready to continue with those witnesses so that they don't have to keep reappearing. But I'm not sure I'm comfortable proceeding with the victim's testimony until both sides have had a chance to review this additional evidence off defendant's phone. As I stated, victim is on her way here. She does have a son. I don't know if she was able to get childcare for him or he'll be with her. So I don't believe we reached a consensus this morning, but I did speak to counsel about, for her testimony, do we need to keep her hid enough sitting in for the record? I'm not comfortable until both sides have looked at the evidence. I'm not comfortable directing her on it, and I'll leave up to counsel how she feels about cross-examining without those pieces. But as for the other witnesses, Your Honor, we would be ready.
Your Honor, we find ourselves in a pretty difficult situation because we have not been able to review all of the information from the thumb drive. I asked Sister Counsel, she's unaware because she hasn't gone through it either, if any of the information in the thumb drive may pertain to the witnesses that are present now and ready to have testimony taken from them. I don't see why there would be. However, there was some information just in the preliminary.
And here's the emotional pivot. The defendant's father is hospitalized, and the stress is hitting him hard. Courtroom drama isn't just legal, it's human. This moment shows how real life crashes into legal life, and why defendants often feel desperate to just get it over with, even when rushing might hurt them.
Pieces that were sent over may have occurred around the time of the interaction with one or maybe all three of the witnesses present today, specifically some communication between my client and the complaining witness. We're not sure who was around at that time, but I just don't know what else is in the phone. There's a great deal. I am not experienced in sieving through this type of data. I'm literally just clicking on every folder or file and
I thought you worked for the NSA. No, I'm sorry. Go ahead.
Is that on the record?
In my prior life,
Yeah, okay.
So, and that's why I find it difficult to say, yes, I'm ready to proceed on the three witnesses that we have. Yes, I'm okay with an adjournment of, the information from the complaining 100%. He has been in custody throughout this entire period. He is very eager to resolve this matter. We received some very disturbing news from his family yesterday. His father's currently in the hospital, and he's been really struggling to assist with his mom. But I know that my conversations with him have always pulled out his desire to move forward and continue this case along. So we're really at a crossroads right now, Judge.
Right. And just so that we're clear, part of the reason the court agreed to adjourn the matter was because my understanding was the defendant believed that there was something that was exculpatory on the phone. And so that's why we even started down this path. I'm not blaming anybody. It's just reference to, I'm sorry, Ms. Eckenroley, were you done?
Sorry.
Okay, no, I just wanted to make sure. With reference, you said you had three witnesses today.
We have three witnesses, Your Honor. Two of them are in the gallery. One is the officer who responded. The other one is a social worker who spoke to the victim at the time at the hospital after the assault. So they would be ready. We also do have Sergeant Matthews. Sergeant Matthews would be able to start today. We may want to recall him after the victim's testimony, depending, but he'd be the third witness that could start testifying today.
Got it.
And I share defense counsel's lack of knowledge of technical things. So when she asked me about the messages, I was able to get through some of them. Of course, not all of it. It is a great deal of evidence. And I would agree that there are text messages, and those we do have timestamps, and Sergeant Matthews could speak to from defendant's phone, defendant messaging victim around the time that it seemed it was becoming clear to him that there might be some police involvement and things like that. I'm not sure if that affects Officer Morton's testimony. I mean, he responded, he did what he did, but I'll leave that up to the court.
Well, I guess I initially, let's take out, there's a social worker to testify who, and this may be the more difficult one for the court to try to analyze, and maybe part of the defendant's point, that
It wasn't me, Your Honor.
oh, you don't care? You don't care? No, man, I feel, that thing goes off, nothing. Then that goes off, nothing. No. You got me? Okay, thank you, Ann. No, don't worry about it. I feel safe. So with reference to the social worker who spoke to the victim afterwards, I would have to say I might be a little bit concerned if there are concerns with what the victim has testified to, and the victim is relaying certain information to the social worker, or maybe the parties can clarify it if they can, or I don't know. It would seem to me that getting through or understanding what's on the phone is also going to be cloaked in that same context as the victim. If that made any sense.
It did make sense, Your Honor, and I'm racking my brain as to with the preliminary information we have.
Timestamps, this word keeps popping up, and for good reason. In digital evidence cases, timestamps are everything. Without knowing when messages were sent, you lose the entire narrative. Imagine reading only half the chapters of a mystery novel, but still trying to guess the culprit. That's exactly what the judge wants to avoid here.
My concern, defense counsel might disagree, my concern isn't necessarily what the victim said. I don't understanding of the evidence, especially with the little of the new evidence I've reviewed, is that the potentially exculpatory evidence, our perspective is that it's not exculpatory because there's a greater context and we have theories and so on. And I think the evidence will highlight that. However, again, like I said, defense counsel might disagree.
Well, and I guess my point to that might be, she might disagree or may not know.
Correct.
Which may be worse.
Yes, Your Honor.
Because it's that greater context, I guess, piece of it, of that evidence that might not only have some greater context to what the victim says, but might also have greater context to what the victim said to the social worker and what the social worker says.
I understand.
Is that sort of what you're referring to, Ms. Atkins?
That's correct, Your Honor. But yes, not knowing what's on the phone, I don't know how it pertains to our social worker or even the officers, because again, there's from the preliminary information, there were some communications that fell within that timestamp of after the event, during the time that other parties began to get involved. I don't know. And we just know that from the preliminary.
And you know, the difference between the preliminary, other than the obvious difference, the preliminary information we're able to get evidence about the timestamps, because in part of that report, in part of the supplement, I believe, Sergeant Matthews outlines this time, this day, this text was sent, and so on. With the new evidence, I don't have a way of knowing the timestamps on it, and the defense does either. So we would need someone to testify to all of that. And I don't know if Sergeant Matthews has had a chance to review all of it, because he similarly had a problem opening the initial files and has only since yesterday had access to all the information off the phone.
And Judge, I just want to, I guess I need to just put this on the record. I know that I think it's important that the court notes never requested for the people to get his phone. My client never requested.
Right. I mean, I agree with that piece, but and I'll certainly let you finish. What my point was, the defendant, at least as I was informed, the defendant wanted his phone, which he believed to be in his property.
Correct.
That is, reason for that is because there was a belief that there may be something that might be exculpatory on the phone.
Correct.
Okay. When the defendant was, or at least the court was aware that he wanted the phone, I was then informed that the police agency had picked up his phone and had his phone. So if anything, I'm saying in terms of the request that it was the defendant who was requesting the police go through his phone, I don't think that's not what I meant to say. What I meant to say is it transpired that way because there was something there. The people, to their credit, then said, if there is something that is exculpatory, then we want to make sure that the defendant has that. So that might be a clear picture, but I'll let you go ahead.
Sure. Yeah, so the piece that the court should probably also note is that the only reason that they picked up the phone was because my client was asking a family member to come and get his phone for him so that he could instruct us on how to get that evidence out of his phone. And the police department overheard that call and then took it upon themselves to come and pick the phone up. And then that's where we got into this entire delay because there was negotiation.
Huge moment here. The prosecution reminds the court that the defendant also has a bond violation and not a minor one. When a judge hears serious bond violation, alarms go off. It changes how urgent the case feels, how they view the defendant's reliability, and how cautious everyone becomes. It's a major twist hidden inside a procedural update.
Negotiations as to how we were going to get it to the phone and things of that nature. So it does not change where we are. I just felt that it was important to clarify the record to that point.
And please understand that I wasn't trying to, and I think I may have said it at the end of my first statement, I'm not trying to blame anybody for the delay. I'm not trying to say the defendant is trying to delay this out or the people. It is what it is. I just wanted it. And I'll take you at your word for how or why they picked up the phone. But suffice it to say that somehow or another, that train started rolling down the tracks.
Correct.
And so
Absolutely.
we all had to deal with it. So.
Even if I could just add one thing, and it's simple for the record, because I know everybody here is aware of this. When we were here and there was information from the defendant that he wanted potential exculpatory things off his phone, I want to be clear, it wasn't a PCC. We were here for exam. The victim was here. People were ready to go. What I want to add to that is that the defendant also has a bond violation, and I know he hasn't been sentenced on that bond violation, and I'm not sure what the sentence would be. But there are many factors that go into this, and that is one of them. And the violation is such that it's not just a minor technical violation; it's quite a serious one.
Yeah. So I guess the defendant wants to proceed right away, and I get everything that counsel has stated, but I'm worried, secondarily, that you'd be placed in a position of attempting to try to cross-examine a witness for your client's benefit, where you don't have benefit of everything. And that really is fundamentally my big concern.
Your Honor, I'd say the people share that concern, and in communications with counsel, I also want to be clear that if we don't continue today, that is not from the people not being ready. That is not from the people saying we don't want to continue. In fact, as I stated, the victim is on her way despite many difficulties to try to make it here, and our witnesses are present. So for as much as it helps to the defendant's benefit, this is us also trying to be very careful in how we go about things. None of us want there to be issues on appeal. We all want to make sure that we're very careful and respecting not only the rights of the victim and the people, but really the rights of the defendant.
Right. Ms. Eckenrode, have you had a detailed conversation with your client about going forward today? I mean, I realize that some of the issues that the court is raising, you may not have because I've raised those, but you're smarter than I am, so you may already thought about that.
And Judge, I mean, if the court is okay with giving me a moment to, now that he's been able to sit here and listen to all sides of it, yeah.
And I'm not going to have a problem with that. Let me, what I've said about the social worker, does either party see with reference to the two officers that same potential issue arising?
Your Honor, it comes down to what Your Honor very eloquently put. We don't necessarily know. I don't have reason to believe. There's nothing I've seen up until now that would suggest that. There's of the things I've seen, there's nothing that would make me think that we could proceed with the officer's testimony. But
I'm sorry, I don't mean to interrupt, but the officer spoke with the victim.
Correct, yes.
Correct?
Yes.
And from speaking with the victim, a report, that's part of the report, right?
Yes, Your Honor. So there was an interview with the victim. There was an interview, of course, with the social worker who had spoken to the victim. And there was at least one interview with the defendant.
Okay. I mean, and I haven't had a chance to necessarily think that entirely through, but it would seem to me, oh my goodness.
Instant smile, Your Honor. Just making sure we're doing our jobs.
I can hang out for a little while for the court's next recess.
Well, I'm out. All right. It is so good to see you.
Thank you. Good to be seen.
I'm happy now. Despite your non-attention to my safety. I'm happy. Let me just put it in a nutshell. It would seem to me, and maybe this would be the conversation that needs to be had, that anyone who spoke with the victim is going to fall, in my mind, into that same potential concern, placing context around what her statements are. I think we're in the same boat. I picked the social worker initially because it was going to be difficult, but there was also going to be a closer conversation between the victim and the social worker. But I think if the officer interviewed the victim, that same thing is going to happen or potentially happen. In some sense.
Your Honor, may we approach just briefly?
Well, no, this is where it starts. You know, I'm going to just tell you, I walked in here, two of my favorite attorneys, and I said, this is going to be a good day to come back from vacation. You have both ruined that. You may have ruined.